Good morning, Mr. Cholula. May I have your full name and your date of birth, please?
Miguel Cholula.
All right, thank you. You are here on a new case. The allegation is aggravated assault in a domestic violence relationship by the impeding of breathing or strangulation. That is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. Your next court date in this case will be a status conference on August 12th, that's this Monday at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be Friday, August 15th at 8:30 in the same court, and that address will be on your paperwork. Bond in your case is set at $15,000. That is secured. Secured means you can use a bail bondsman. If you post that, you will be released on an electronic ankle monitor under the supervision of pretrial services. The purpose of the ankle monitor is to keep you away from the alleged victim. Whether you are in or out of custody, you may not have any contact with the alleged victim. You may not respond to any contact from the alleged victim. No weapons, no drugs, no alcohol. Obey any and every order of protection that may be served on you. If you'll step out to your left, I'll give you a copy of your paperwork.
I just have a question.
What's your question?
So I understand the guy was put on the aggravated assault, but I had no idea that that's what the case was being charged for. They didn't even tell me that's what I was being charged for. Aggravated assault was what everyone was telling me. So is this just something that changed recently?
You're saying the police were discussing something else? That's not relevant to what they booked you on in the court's probable cause finding. People often say the police said that was only a misdemeanor. Talk to your lawyer about that. They booked you for a felony. The elements of the crime are satisfied, and take anything else up with your lawyer. But things the police may say to you about what they think they're investigating or what they say they're investigating.
But that's for my paperwork, so that's why I was asking.
Well, I'm here to tell you that whatever was told to you, you were booked on one count of aggravated assault in a domestic violence relationship by the impeding of breathing or strangulation. That is a Class 4 ag assault. There is probable cause for it. So talk to your lawyer about what the elements of that crime are and what you may ultimately be charged with by the county attorney's office. This is your booking charge. There is probable cause for it. You have to post bond to be released. You go on an ankle monitor. I do recommend you look up the statute that I listed in your paperwork. It's the one that says a single act of harassment committed while there is a no victim contact order in a criminal case is a new felony. And if you're booked on that, you will be held no bond, just like the last guy. Do not violate the no victim contact orders. This court, in fact, the entirety of the nationwide legal system takes domestic violence strangulation cases extremely seriously because there's significant research to establish that it greatly increases the risk of future domestic violence and multiplies the risk of murder by 7 times, by a factor of 7. I'm not saying you're going to do that. What I'm saying is this is a sharp red flag for violation of release conditions and future violence, victim or witness intimidation. If you were to engage in any of that, you could easily land back in here on an aggravated harassment allegation, in which case I would hold you without bail at this hearing. Do not violate your conditions. Do not fail to take this seriously. As I noted in your paperwork, the county attorney filed a written recommendation in your case for $50,000 bond, 50. I set it at 15. You do not appear to have criminal history or a noted history of domestic violence. Generally, people brought in with this level of alleged evidence, it is not their first rodeo for domestic violence. What they've alleged against you is significant. If they have the evidence they have, it is a strong weight of evidence. I am factoring that in the calculus of whether you pose a future danger to this victim. So, talk to your lawyer about modifying any release conditions that you may have. This is your bail. You will wear the ankle monitor if you post it. Do not try to call her from the jail, even on someone else's PIN. Guess what? It doesn't work nearly as well as people think it does.
I get it.
All right.
And just one more question. And you said with the ankle monitor, that's still set at like 15,000.
Correct. The ankle monitor is to keep you honest, whether you post it or not. These are cases where the violation of no victim contact orders is rampant. And so you will stay away from her. You can work. You can go to school. You will establish with your surveillance team where you're allowed to be and where you're not. But you will be tagged with an ankle monitor.
So there's no way to actually do any kind of like payment or anything for that?
No, and the fact that you really, really don't want it concerns me. I don't know why you don't want it.
Because I'm saying, like, I honestly don't have a lot of money. The whole reason I even fought her for those bags, because I don't have a lot of money. Mr. Cholula, I'm concerned that you're going to say things that could be used against you in order to try to get better release conditions. I'm a little...
So I have a Fifth Amendment warning I'm willing to give you, but Mr. Cholula, I'm trying to let you know that the county attorney's recommendation, I know why they recommended it. It is not their standard recommendation. So right now, $15,000 is about the best you're going to get from me, but I will give you a Fifth Amendment advisement if you want to keep talking about what you're accused of. Do you want to keep talking about what you're accused of? Because I want to give you the advisement, and then I'll...
it's probably not going to help any more than that, so probably not, right?
That's up to you. If you want to keep talking about it, then I give you the advisement, and if you want to keep doing it, I will let you. But I'm going to stop you until I give you the advisement.
The whole reason I even fought over it...
Okay, stop. This is your advisement. Please listen.
Yes, I hear it.
Do you remember that you have the right to remain silent?
I remember this.
Sir, if you interrupt me, it'll just take longer. Do you remember that you have the right to remain silent?
Yes.
Do you remember that you have the right to the assistance of an attorney?
Yes.
Do you understand that I did appoint an attorney for you, but they are not here in court with you?
Yes.
Do you understand that your attorney can tell your side of the story without it being held against you? Do you understand that? That's a yes or no?
That's a yes.
Okay. Do you understand? You may not know this. This hearing is being audio and video recorded. Do you understand that?
I understand.
Do you understand that the things that you choose to say could be used against you, either now or at any later hearing, including your trial in this case?
I understand.
All right. So, Mr. Cholula, do you understand that the court will consider anything that you choose to say, but the court encourages you to not speak about what you've been accused of because it could be used against you? That being said, I will not stop you. Do you understand the distinction?
I understand.
All right. Was there anything else you wanted to say on the setting of bail or release conditions? Now you have free reign. Say what you want to say.
I just want to say, I don't really have that kind of money to be, I understand I'm probably just going to be held till Monday, which is honestly not really much of the thing, but, I really felt that I was going to at least get a lot of my details looked over with as to what happened, especially with the recent, I had called against her for my cat. She held against her, but she didn't want to give me it back. And this was the second time she was just keeping my own stuff from me. And I got a lot of debt, man. That just stressed me out, man. I was just really trying to get my stuff and leave. She just fights me every time. I'm not even trying to fight her. I want to leave. And this last moment, I wanted my shit, man. I just wanted to get it, and it was worth like my cards are worth money. I was like, I want to sell this shit and just help my own ass out with my dad because I had done so much for this woman just to help her out.
Mr. Cholula, I can understand that you're very upset, but you're right. At this point, that does not rebut probable cause. In 1 second. Okay, hold on. One second, okay. I just realized there is a victim impact statement that was filed that you'll have to obtain through your lawyer. I am obligated to read it. Hold on 1 second.
That's fine. Go ahead. Sorry. I'm a little emotional. I'm sorry.
All right. I've also considered the victim impact statement, which you, like I said, you will have to obtain through your lawyer. So, Mr. Cholula, it's fortunate for you I didn't read that first. I'm not going to up your bond, but reading the victim impact statement makes me believe that $25,000 to $50,000 is probably more appropriate. I understand you're innocent until proven guilty. These charges haven't been proven against you. But, Mr. Cholula, this is a case in which you may face some serious consequences. And the court believes that there is a real and patent potential for further victim or witness intimidation. Please keep in mind, in my release conditions, you may not contact her directly or indirectly, no third parties, no social media. If you play games with no victim contact in a DV case like this, every person in this system who wears a black robe takes it very, very seriously, because none of us wants to be the person that released the one who went out and killed her the next day. And I'm not saying that's you. What I'm saying is there are many red flags in what is being alleged against you. This is the appropriate bond based on the way that we set bonds. You can speak to your lawyer about trying to get the trial court to set a lower bond for you. But Mr. Cholula, let me just repeat. If I'd read that victim impact statement before I came in here, we'd be talking 25 to 50. And I don't mean that to say that I didn't consider what the victim said. But I've considered also what you said, what she has said in her victim impact statement, and I'm balancing those and leaving it where it is. So, Mr. Cholula, that is all the time that I have for you. I'll give you one more chance if there's something you wanted to say, and then I need to move on.
I mean, if there's nothing else that's going to impact it more than whatever you read, I'm not sure what it is, and there's just no point in it, and I'll just have to talk with my lawyer at that point.
All right. If you stepped your up, I'll give you your paperwork. Thank you.
Judge, you left it at 15 though, right?
Sorry?
You left it at
I did, indeed, yes. Mr. Yates? And then Freddie Cruz, will you please go to the chair? Good morning, sir. May I have your full name and date of birth?
Michael Yates.
Thank you, Mr. Yates. You're here on a new case. You were arrested for aggravated assault with a deadly weapon or dangerous instrument, which this court finds probable cause for as a Class 3 felony under Arizona law. Also for disorderly conduct with a weapon, which is a Class 6 felony. There is probable cause for both of those things, and I am appointing a lawyer for you. Your next court date will be a status conference. This is Monday, August 12th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing August 15th at 8:30 in the same court. Your bond is $5,000. That is secured. If you post it, you go on an ankle monitor to ensure that you stay somewhere else while the case is pending. You may not go to nor reside anywhere in that apartment complex while the case is pending. You may do a civil standby. I will repeat it, sir, as many times as I have to. I realize I just had a long discussion with him. I'm telling you, on these facts, I will not. There's nothing you're going to say that it will make me allow you to live there while the case is pending. No, just let's not go there. You will find another place to stay. You can do a civil standby with law enforcement to collect belongings. The county attorney recommended $25,000 in your case. Your priors and your history is fairly old. I've considered the exact weight of the evidence they've alleged against you. $5,000 is the lowest I'm going to go. I'm not going lower. This is a gun case, and neighbor cases are extremely volatile. I'm not going to let you live there while the case is pending. Do not contact them from jail. Do not respond to any contact from them. You may only go to that complex if you bring a cop with you, on no other basis. No weapons, no drugs, no alcohol. Everything's on your paperwork. Talk to your lawyer about a motion to modify that. All right, step to your left to get your paperwork.
Can I ask a question?
Sure.
I don't understand it's like a violence charge, but I didn't do anything to anybody.
They allege that you did. The video demonstrates, I think, if they have the video they say they have, it clearly demonstrates disorderly with the weapon. I set bond more appropriate to that, but there is absolutely an allegation that apart from that video, you pointed the gun. I would set this bond even if they had not alleged that you pointed the gun. So you can talk to your lawyer about a motion to modify it, but there is an allegation that you pointed it. There is also a legal argument to be had that holding it at your side while you have an argument with somebody puts them in a reasonable apprehension of imminent physical injury. That argument absolutely exists, pointing or not pointing. The law does not require pointing. So talk to your lawyer about that.
I was just trying to protect my family, Judge. I got two
I
little
can understand
kids,
that. That's why bond.
I got a history with those neighbors. I've been to the office complaining.
And guess what, Mr. Yates? History with neighbors equals future violence.
Right.
Neighbor cases end up in murder. It might be you who is the victim. That is why the court's orders are set to keep you separate. You are the person standing in front of the court for probable cause on 2 felonies, not them. I have no power over them right now. I have power over you.
So I'm going to lose my job. That means I don't have employment.
Mr. Yates, please talk to your lawyer. This is as low as the court is willing to go on a gun allegation like this. All right? If you step to your left to get your paperwork. Good luck, sir. Mr. Cruz?
Is that Freddie Cruz? Yeah.
Yeah, Mr. Cruz, and then Diana Espinosa, please. All right. Hi, sir. Can I have your full name and date of birth, please?
Freddie Jean Cruz, 39.
Thank you, Mr. Cruz. You're here on a new case. You were arrested for dangerous drug possession, a Class 4 felony. There is probable cause for that, and I am appointing a lawyer for you. Your next court date is a status conference Monday, August 12th at 8:30 in the morning in the downtown Superior Court. Preliminary hearing August 15th at 8:30, same court. That will all be on your paperwork. Based on your criminal history and what's been alleged against you, bond is set in your case at $2,000. That is secured. If you post it, comply with all of your written conditions, particularly no weapons, no drugs without a valid prescription. If you step to your left, I'll give you your paperwork. Thank you. Ms. Espinosa? And then Casey Gresh. Hi, ma'am. Can I have your full name and date of birth, please?
Diana Espinosa.
Thanks. You're here on one new case and one probation hold. In the new case, you were arrested for narcotic drug possession, a Class 4 felony, and assault as a Class 1 misdemeanor. There is probable cause for both of those, and I am appointing a lawyer for you. I'm also appointing a lawyer in your probation case. You are on probation for a Class 6 felony, and the probation department will be filing a petition to revoke your probation based on this new arrest. So you need a lawyer, and there will be a petition filed between now and your next court date. You'll get a copy of that from your lawyer. And I think I have to give you different court dates to begin with. I'm sorry, but they should come together in the system eventually. Your first court date will be in the new case, and that is Monday, August 12th at 8:30 in the morning. That's this Monday for a status conference, with your preliminary hearing that Friday, August 15th at 8:30. In between those, on August 13th, which is 1 week from today, you'll go to probation court, 8:30 in the morning, for a revocation agreement and a possible disposition hearing. The addresses for the court will be on your paperwork along with those dates. All right. In each of these cases, actually, you have a $500 secured appearance bond. That is $1,000 total with written conditions. If you bond out, you need to comply with all of those, particularly call your PO within 72 hours of any release from jail. If you do bond out, the number's on your paperwork. Good luck, ma'am. Mr. Gresh, and then Mr. Carpio, we go to the chair. Hi, Mr. Gresh, can I have your full name and date of birth, please?
It's Casey James Gresh.
What's your date of birth, sir? All right, thank you, Mr. Gresh. You're here on a warrant from the El Centro Justice Court, which is downtown. You've been charged there with third-degree criminal trespassing. It's a Class 3 misdemeanor. This warrant issued after you failed to appear again on, just one second, on or about May 16th of this year. So we're going to give you a new court date there. It is August 8th, which is 2 days from now, the day after tomorrow, 8:30 in the morning in the El Centro Justice Court downtown. The address is on your paperwork. This is your third failure to appear in this case. You also have misdemeanor warrants from Phoenix. Bond is set in your case at $50. It is secured. If you post it, comply with your conditions. Do not miss your court dates. It's on your paperwork. If you don't post it, you'll see the Justice of the Peace day after tomorrow. Please step to your left and get your paperwork. Thank you. Mr. Carpio?
Go right out to the door, please.
Or Mr. Vasquez Carpio, I don't know which it is. And then Alicia Butterfly, will you go to the chair right here, sir? Hi, can I have your full name and date of birth, please?
Daniel Medal Carpio Vasquez.
I'm going to fix your name in my system. I'm not going to reprint for that because you got charged in a criminal complaint as Daniel. Let me pull up the warrant. Hold on. There's been a criminal complaint filed against you, and it's got several alternative names. It charged you as Daniel Medardo Carpio. Talk to your lawyer about getting your name corrected downtown, because even if I change it in this system does not talk to the downtown computers anymore. So you need to get that straightened out with your lawyer about your true name downtown, okay? But I've at least noted it in our system. It was 12/23 of 02?
Mm-hmm.
Okay, thanks. You're here on a warrant. And that's because charges were filed against you that date back a little bit. They are 1 count of narcotic drug possession, class 4 felony, 1 count of drug paraphernalia possession, class 6 felony. The alleged offense date is November 1st of 2023, and all I can tell you from the warrant today is that it comes out of the Chandler Police Department. But if that doesn't ring a bell, you will get a copy of the charges and police reports from your lawyer. I am appointing a lawyer for you. Your next court date is going to be a status conference August 21st, which is actually 2 weeks from tomorrow, the 21st, 8:30 in the morning in the Downtown Superior Court. Your preliminary hearing will be that Friday, August 23rd, 8:30 in the morning, same court, and the address will be on your paperwork. This is not a newly filed case, and you do qualify for release to pretrial services. It looks like they actually tried to send you a summons a couple of times, but didn't have a working address. We don't hold that against you. Just make sure your address is updated when you get to your first court date, okay? Or this is going to happen again. So I'm releasing you to pretrial services. What that means is you'll be released. You're going to get an envelope with instructions about when and how to call them. If you lose the envelope, you're not going to comply. And also your paperwork tells you where to go. Don't lose your paperwork either, okay? Go to court?
Mm-hmm.
All right. Go ahead and step to your left. She'll give you paperwork. Good luck.
Thank you.
Ms. Butterfly? And then Mr. Reyes, John Reyes, will you please go to the chair? Hi, ma'am. Can I have your full name and your date of birth, please?
Alicia Butterfly, 17.
You're hearing a new case. You got booked into Peoria City Court for false reporting to law enforcement. That's a class 1 misdemeanor, and there is probable cause for it. I'm not appointing a lawyer for you, though, because we don't appoint lawyers in this type of misdemeanor case. You always have the right to hire a lawyer at your own expense or to just represent yourself.
Okay.
Your next court date is going to be in the Peoria City Court, August 22nd, which is a little over 2 weeks from now, 9 in the morning.
Okay.
The address is on your paperwork. I'm going to release you. You're not accused of hurting anyone. What you need to do is go to court, comply with your conditions, which are very simple. No drugs without a valid prescription, no driving without a valid license.
Okay.
Okay, everything's on your paperwork. If you step to your left, you grab a copy. Thank you, ma'am.
Thank you, Your Honor.
Mr. Reyes. And then Mr. Lewis, we go to the chair. Ethan Lewis. Hello, sir. Can I have your full name and date of birth, please?
Don Anthony Reyes,
Thanks. You're hearing a warrant from the North Mesa Justice Court. And in this case, you've been convicted of driving on a suspended license. It's a class 1 misdemeanor. This is a failure to pay or failure to comply with conditions warrant from September of 2021. I'm not appointing a lawyer for you because you've already been convicted. Your arraignment hearing will be August 22nd, which is a little over 2 weeks from now, 1 in the afternoon in the North Mesa Justice Court. I'm releasing you because even though this is an old warrant, it's about 3 years now, it's your first failure to pay. You got arrested and you went last time and pled. I hope you don't like being arrested. I don't know if your driver's license is currently valid. I don't really care at this point. Don't drive to this court hearing if it's not. But if you don't go, this happens again, and then we're going to give you a bond. I don't want to hold you for non-payment, but if you won't go to court, you'll get a bond next time. So hopefully you don't enjoy this experience and you'd rather just go to court.
Yes, ma'am.
All right, if you take your paperwork, it's still going to take hours to be released, which helps to reinforce the idea that you don't want to come back. All right, good luck, sir.
Thank you.
All right, Mr. Lewis, Ethan Lewis.
He's been so anxious.
This guy? Oh, hi, sir. Can I have your full name and date of birth, please? Your name, sir?
Ethan David Lewis.
Okay, thanks. You're here on a new case. You were booked in on one allegation of possessing narcotic drugs. It's a class 4 felony. I am appointing a lawyer for you, and I'm going to give you a couple of court dates. So your first one is a status conference 2 weeks from tomorrow, which is August 21st at 8:30 in the morning, status conference. Then, that Friday, August 23rd at 8:30, is your preliminary hearing. The address is on your paperwork. Now, I'm not giving you any other release conditions because I did not find probable cause in your case, which does not mean that it's dismissed. It means you're entitled to be released, which is nice for you today because if there had been probable cause, I would have held you without bail because you have an open and pending felony case. You remember that, the trespassing? And it looks like you're in suspended prosecution, that counts as an open case. So I like to call that felony walking. If you do any felony and there's probable cause, you get held no bond. Or I should say it's no bond walking. So you need to go to court on the 21st. I put a phone number on there. You can check into it before you get there. And Mr. Lewis, I don't have any real doubt and would likely stake a lot of money that what you had was cocaine, but the police didn't meet the legal standard for probable cause, and that's what I have to apply. But Mr. Lewis, I also view this as a giant screw-up, because even if they don't file it right now, they're going to wait for the lab results maybe, I don't know. Talk to your lawyer about that when you get to court. One day, they're going to file it, and then you'll be held no bond, because it's a timing issue. Even if you're already on probation in the task case, even if you are successful in the suspended prosecution that's dismissed, that is not a defense. You will be held no bond. And so I know you're kind of young, 2003. I don't know if you're smiling because you're nervous, or you're just, this isn't real to you until it becomes real. I don't know. It's a little odd. I'm releasing you anyway. I'm just trying to give you a clue, Mr. Lewis. You need to not pick up any new charges.
Oh, my God. There wasn't the Olympics.
Oh. Playing with drug possession, I don't know. I guess I don't know. You're, okay. All right, Mr. Lewis, I'm going to make the assumption that you're nervous and or perhaps cognitively impaired. So I'm going to release you. Do you understand the things that I've told you?
Yes, ma'am.
Well, Mr. Lewis, I fear we're going to see you again real soon, but that's entirely up to you. Good luck, sir. Yeah, that's odd. It's like a YouTube guy who films his own felonies.
Yeah.
They do that. Strange kid.